This is Commercial Leasing Part 2. So we have determined that there are 5 essential elements to a lease. We now need to consider them in more detail. So A, parties. To be valid, a lease must describe both the landlord, the tenant, and any guarantors or indemnifiers. The tenant should ensure that the person purporting to be the landlord is in fact the registered owner of the land or the beneficial owner of the land. A land title search will determine the registered owner. If the landlord named in the offer to lease differs from the registered owner, the tenant must obtain an explanation as to the difference to ensure the party described as the landlord in the offer to lease has the right to lease the premises to the tenant. The registered owner may be holding the land in trust for a beneficial owner. The beneficial owner is the real owner of the land. A landlord should undertake a BC Register of Companies search on a corporate tenant to determine A, if it is incorporated in British Columbia, or if not, if it is extra-provincially registered in British Columbia, and B, the correct legal name of the tenant. It is critical that the parties to be properly described, failing which there may be no binding relationship between the parties, or it may be that an individual signing the offer to lease may inadvertently find that the individual itself is personally liable as the tenant. B. Description of the premises. There must be a description of the premises which is sufficient to adequately identify the property being leased. If there is uncertainty, a court may look at the surrounding circumstances to determine the boundaries of the premises being leased. An offer to lease may set out the method of measurement of the area of the premises. This may be the Building Owners and Managers Association, BOMA. We will discuss the different methods later. Or Society of Industrial and Office Realtors, SIOR, standards, or it may describe the landlord's specific measurement formula. These formulae may address such items as to whether there is to be included the thickness of the walls, indentions for doors, windows, shafts, or stairwells. If the lease is for space in a building characterized by horizontal measurements, then the space includes the space between the floor and the ceiling of and the walls, partitions, and fixtures within the measurements. Scythes and Company versus Gibson's Limited, 1927, SCR 352 SCC. It is important to determine what comprises the premises. This determination will be instrumental in A, calculating the per square foot rent, B, determining the tenant's proportionate share of operating costs and taxes, C, determining the responsibility for liability, as the responsibility may be determined on whether an incident occurred in the premises. D, determining the responsibility for repairs. The tenant will be responsible for repairs in the premises. And E, determining if exterior areas such as patios, decks, loading docks, and parking are within the premises and therefore for the exclusive use of the tenant. In a perfect world, it is useful to have attached as a schedule to the offer to lease a formal plan prepared by a BC land surveyor describing the premises to be leased. If you are leasing premises other than a building or part of a building, you must also take into consideration Section 73.1 of the Land Title Act of British Columbia, which reads, except on compliance with this part, A person must not subdivide land into smaller parcels than those of which the person is the owner for the purpose of A, transferring it, or B, leasing it, agreeing to lease it for life or for a term exceeding 3 years. In order to comply with Section 73.1 of the Act, it is necessary to obtain approval from the appropriate approving officer of the municipality in which the land is located. Failure to do so will, subject to Section 73.1 described below, result in having the lease being declared invalid and unenforceable. This matter was addressed in the British Columbia Court of Appeal in the case of International Paper Industries Limited versus Topline Industries Inc., 1996, 20 BCLR 3D 41CA. The case stated that when a portion of a property is leased, the failure to subdivide the property in accordance with the Land Title Act will result in the lease being found void. Where a portion of a building or the whole of a building is being leased, the foregoing subdivision provisions do not apply. See Section 73.3 of the Act, which provides for this exception. Section 73.1 of the Title Act was brought into force on May 31st, 2007 to address the Topline decision. That section states as follows: a lease or agreement for lease of a part or a parcel of land is not unenforceable between the parties to the lease or the agreement for lease by reason only that A, the lease or agreement for lease does not comply with this part, or B, an application for the registration of the lease or agreement for lease may be refused or rejected. Section 73.1 only applies to leases entered into after May 31st, 2007. It is not retroactive. Leases entered into prior to that date which were void are still void. You will need to take this into consideration if you are considering the subleasing of premises subject to a pre-May 31st, 2007 lease or the assignment of such a lease. I draw to your attention that the specific statement is that the lease or agreement for lease is not unenforceable between the parties to the lease agreement for lease. Arguably, it would not be enforceable against the landlord by an assignee of the tenant or a mortgagee of the lease or a mortgagee of the lands. I'm not aware of any reported decisions addressing this matter to date. See commencement of the term. There must be a certain beginning and a certain ending, otherwise it is not a perfect lease. Marshall versus Barrage, 1881, 19 CHD 223 at 243 CA. The commencement date does not need to be stated as a precise date, for example January 1st, 2017, provided that there is wording sufficient to enable the commencement date to be determined. For example, it may include an event such as delivery of the landlord's certificate confirming that the premises are ready for fixturing. See Cedar Invest Limited versus Kohler, 1985, for RPR 75, or the earlier of the expiry of the fixturing period or the tenant opening for business in the premises. C 2030068 Ontario Limited versus Coffee Time Leasing Corporation, 66 RPR 4th 280 Ontario SCJ. D. Duration of the term. For a term lease, the term of the lease will be for a specified period of time, such as a number of years. The duration of the term must be specifically set out or must be easily determined. There must be certainty. For a periodic tenancy such as month to month, the end of the term is not specified, but the duration of the term is considered to be certain because the tenancy is terminable by either party on notice. A year-to-year tenancy requires 6 months' notice to terminate. The termination must coincide with the expiry of the yearly term. A month-to-month tenancy requires 1 month's notice to terminate, coinciding with the end of the next monthly rental period rent. E-rent. The rent must either be a fixed rent and stated in the lease, or an amount which is determinable. The three most common charges for rent in a commercial lease are A, annual basic or minimum rent. This is usually determined based on a per square foot or per square meter basis, or maybe a fixed monthly amount. B, tenant's share of operating costs and taxes. These taxes are charged as additional rent. Operating costs and taxes may be based upon a base year or may be the tenant's proportionate share of the actual costs in any specific lease year. The operating costs and taxes are usually estimated with the tenant paying 1/12 of the estimated amount monthly, with an adjustment being made at the end of each lease year. C, percentage rent. This rent is specific to retail premises and may or may not be included. If it is applicable, this rent is calculated as the percentage of the gross or net sales of the tenant as defined in the lease, and is payable if the calculated amount exceeds the annual base rent in the specific period. The lease will have to be reviewed to determine how the landlord is determining gross or net sales, and the lease will have to determine what is to be deducted from such amounts. The percentage is usually negotiated. You will know that amounts payable as minimum rent, additional rent, and percentage rent are generally stated to be rent. This gives the landlord those rights available to it in the lease or at law for rent in arrears, including the right of distress. You will note that in a typical lease, rent is to be paid without set-off, deduction, or abatement. This means that the tenant, if it has a claim against the landlord for payment of any monies, cannot set off that claim against the rent payable. F, any other material terms. Items that are material to a party or to both parties need to be specifically set out. In the event that they are not, the offer to lease may be regarded as being in the negotiation stage. The nature and type of such terms will vary from situation to situation. They may include, for example, a landlord's right to terminate for redevelopment, the landlord's right to relocate the tenant's right to terminate in the event the landlord wishes to relocate, or in the event an anchor tenant is not found or an anchor tenant leaves the project. Tenant improvements, landlord improvements, fixturing, tenant improvement allowances, renewal extension rights, parking exclusivity, hours of operation. So, test your knowledge. 1. Is a letter of intent binding? Yes, no, or maybe. How many essential elements are there for a lease? 4, 5, or 6. The offer to lease will never become the lease agreement, true or false. All right, 5 types of leases. You will no doubt hear reference to gross leases, net or triple net leases, and percentage rent leases. So A, gross lease. In a gross lease, the rent includes the basic rent and the tenant's share of operating costs and taxes. Utilities such as electricity or gas, if not separately metered, will also be included in the gross rental amount. If they are separately metered, they will likely be to the tenant's account. Just because a lease is stated to be gross, it may not be truly gross, and there may be exceptions, for example, signage. It is my experience that gross leases are usually applied in the case of short-term rentals and usually for a small office or small warehouse. Example, if the area is 1,000 square feet and the landlord is charging $11.25 per square foot, the tenant will pay a total of $937.50 per month plus applicable taxes. B, net rent lease. For the purposes of this discussion, I have chosen to describe a net lease as that situation where the tenant pays its percentage share of taxes or operating costs in excess of a base year. In this form of lease, the basic rent for the base year includes operating costs and taxes up to the base lease year, and for lease years subsequent to the base lease year, the tenant will pay its proportionate share of any increases. There may be exceptions for signage or seasonal charges, such as snow removal. This is not a common form of lease. Example, taxes for the first year are $4 per square feet and operating costs are $9 per square foot. The parties agree that the rent for the first year of the term, inclusive of the taxes and operating costs, is to be $27 per square foot. For each lease year after the first lease year, the tenant will pay $27 per square foot plus its proportionate share of any increase in the taxes and operating costs. If the taxes and operating costs don't change, the tenant will continue to pay $27 per square foot. If taxes increase to $5 per square foot and operating costs increase to $10.75 per square foot, and the tenant's proportionate share is 7.5%, the tenant will pay an additional 8 cents per square foot for taxes. So it would be 0.075 times $1 being the increase in the taxes over the base year, and 13 cents for operating costs, 0.075 times $1.75 being the increase in the operating costs over the base year. The total would then be $27.21 per square foot plus applicable taxes. And that's it for this part 2. Stay tuned for more. Thanks.